The broadcast is now starting. All attendees are in listen-only mode.
Hi everybody, and welcome to today's webinar, Social Security Debt Recovery, Recent Developments, Part 2. So before we get cracking, I'm just going to make sure that everyone can hear me and that the sound is working. So if you can press the button that looks like a hand on your GoToWebinar control panel, I'll see those hands go up here, and then we can know whether you are able to hear. All right, that's fantastic. I'm seeing lots of hands going up. That's great, thank you. I'm just going to pop your hands down now. So my name's Carly Hanson. I'm from Community Legal Centres Queensland, and with us today we have Peter Sutherland from the ANU School of Legal Practice, and he'll be talking to us about Social Security overpayments. So what I would like to do first is to acknowledge the traditional owners of the land on which we are holding this webinar. So I'm in Brisbane, and the traditional owners here are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, and Peter is also attending today from Canberra, I believe, I'd like to also pay my respects to the traditional owners of the land throughout the country and welcome any Aboriginal and Torres Strait Islander people we have listening today. So Peter, as I mentioned, will be talking to us about Social Security overpayments, and this is the second webinar in his two-part series. So Peter will expand today on debt recovery and look at things such as waiver for administrative error, waiver in special circumstances, departure prohibition orders and reparation orders. Peter's delivering this webinar for us in partnership with the National Social Security Rights Network, so I'd like to also acknowledge them for their assistance in arranging today's session. We'll also have a few polls today, so they'll pop up on your screen. So when prompted to do so, please make sure you provide your input, and that will help make today's session a really rich and interesting webinar. Now, in terms of resources, there are a few resources that are available. So this morning I sent out Peter's PowerPoints, and they've been uploaded to the handouts part of the GoToWebinar control panel. And Peter's also developed a paper to go with today's session, and which is also available to download on the handouts section of the panel and on our website as well. If you missed part one of the webinar series, you can have a look at that on our website. I have provided the link in the email, I believe, and also on our website as well, or you can just search for Social Security overpayments. Today's webinar will be recorded, and we'll be sending out the recording on Monday and uploading that for you as well. And lastly, questions. We'll hold questions over, as we usually do, just to the end of the session. So when we get towards the end of Peter's session, we'll have 5 or 10 minutes at the end. Please make sure you type your questions into the question box, or we can take questions verbally by putting your hand up on the GoToWebinar control panel. So without further ado, I will hand over now to Peter Sutherland to have a chat to you about his work in Social Security debt recovery and some of the recent developments in that area. Thanks, Peter.
Thank you, and welcome. Now, I imagine not everybody has attended the first webinar. This is now part 2. It's part 2 because I didn't get through the original paper. It was slow and tedious, and in particular, I jumped very quickly over issues of non-recovery of debts. In other words, the really important issues of waiver and write-off. And so, what I'm doing today is I'm revisiting the whole of the previous webinar. I'm going to run through some of the same material, but at a higher level, and then at a more detailed level once we get to part 5.4 of the Act. So I'm hoping that what I say today will actually stand alone for people who didn't hear the first webinar, but you can always go back to the paper from that webinar, which is more detailed in the first half. I've prepared a paper for this one, which only half an hour ago, went up to Brisbane and is now up on the website. I'll be working through the paper. I'd suggest that you might want to keep it, and there's things like the case citations at the end, so you don't need to sort of try and scrabble citations. I'll work through the paper pretty directly. Now, what I'm aiming at here is it is law. Like we're talking, I'm aiming this discussion at lawyers and paralegals, not necessarily who work in this specific field of social security, but just generally the administrative law and the community legal sector and so on. I'm not, and I'm talking cases. I'm talking to some extent strategies, or what I can make sense of the cases, and it's not something that is a manual, just a manual for trying to understand the Social Security Act. I'm talking about the law in the cases here, and it may not be what sort of somebody who works at the front desk, at the front counter, actually needs or wants. But mostly last time, it was lawyers and paralegals, and I think we only had one person who said the material was simply unuseful, completely unuseful to them. Now, I think it would be useful to run the first poll, just who's in the room or on the web with us. Just helps me. So what I've got is just what I'm going to run through today. I'm going to go through context. So I'm moving through the first half of the last presentation. Then we'll move to part 5.2, just very briefly, amounts recoverable, and parts 5.3, methods of recovery, because I think I did cover those last time, and there's not a lot to say. And I will jump into bankruptcy, it's an important area, just to make sure people are clear about that. Then we'll move on to part 5.4, which will be the core of today's talk. I'll go back over a little bit of ledgers of history, but then I'll move on to write-off, which today is probably not particularly relevant in the scheme of things, because waiver is the much more important issue in terms of Social Security debt. Well, I'll look at waiver generally under part 5.4 of the Act, and then work through each of the sections, and in particular, I will spend time on the administrative error waiver and the special circumstances waiver, because they're the important ones. Now, do we have a result of the poll, just to see how we go there?
Yes, so just under polls, you should see the result, Peter. So we've got 76% CLC or laid lawyer. Just on the GoToWebinar control panel under polls, you should see the responses.
Oh yes, okay, got it. Thank you. Not particularly familiar with this technology. It doesn't. There we go. Okay. Oh, well, that's interesting. That's interesting. So really, it's not paralegal. It's actually people who are working as lawyers in this field and CLC legal aid. That's a very specific audience. Great, and that suggests sort of a quite strong Queensland influence, and also perhaps the national welfare rights influence as well. That's really interesting. And also, there's no other practicing lawyers. I was thinking there are private lawyers and so on. So, very specific group, and then a smaller group of community sector workers. Thank you. I suppose that's what I wanted to see there, and then I need to put that away. There it goes. Now, I think we're going to look at a second poll, which we could pop up as well. Now, just to find out the level of Social Security familiarity and experience. Again, I did this last time, and what was interesting, I think there's perhaps fewer or no paralegals this time, and there's a very high proportion of lawyers. So that's a bit of a difference from last time to this time. I must have really shaken the paralegals out of, must have bored them to death, I think, unfortunately. So going back to my overview, once I've talked about administrative error and special circumstances, I'll hope this time to go briefly to departure prohibition orders and briefly to offences. Though again, it's not a core part of what I want to talk about today. So I suppose we could start. Because the poll's open, can I not change the...
Yep, so that one's already running, and we're collecting responses for maybe a few more seconds.
Okay. just the legislative history. It's all in the paper. So for those who really want to get some detail, I'd go to the paper. But the Social Security Act 1947 was the core of the game until 1991. The 1991 Act was actually intended to be a rewrite, but with no significant policy changes. But under the 47 Act, this whole area of overpayments and debt recovery was comprised in simply two sections of the Act, Section 246 and Section 251. That's no longer the case with the Social Security Act 1991 because it's had a terrible inflation in size as a result of drafting styles. Just in terms of the 47 Act, Section 246 created a debt. Not all overpayments were debts in the 1947 Act. There was a sort of a limitation on the ways that overpayments became debts. And Section 251 provided a broad discretion to waive, and that broad discretion to waive was really just one section, fairly broad in its terms, and it led to considerations such as the most important one, Director General of Social Services v. Hales, 1983, full federal court, which created a sort of a set of principles for how to exercise that general waiver power, and that those principles in Hales have actually flowed through to to Australian law generally, that where there is a really open discretion in a beneficial legislation, you tend to find the Hales principle flowing to the top in terms of the waiver in terms of debts and waiver. In the 1991 Act, it was an attempt to be plain English. That sort of worked, but unfortunately, the actual Act itself didn't work very well because they made the Act about I can't remember now. It was something like about 1,400 sections. It was bigger than a book, and that was coming from the 1947 Act was really quite a small volume. And the reason this happened, and it was a big mistake, was they tried to replicate everything in relation to each entitlement. So all the administration material provisions and all the payments and all the notices and just about everything was repeated for every single payment. And so we had Chapter 2, the payments chapter, just chock-a-block full of administration material. And also, it was a bit of a failure that way, and it was corrected in when the whole Social Security law and family assistance law were reworked in 1999, commencing in 2000. The other reason why the 1991 Act, the ambition to sort of try and have it as a comprehensive statement, is that it just didn't keep up with the fact that this legislation changes at the drop of a hat. They keep massive amounts of amendment, almost similar to the sort of level of amendment in the Taxation Act when you get right down to it, and that's being driven primarily by targeting. They keep trying to cut the stones, target down to smaller and smaller groups and exclude other groups, and the end result is immense complexity in legislation. So we did improve the structure of the Act when they brought in the Social Security Administration Act, because at least a lot of the common provisions were now just said once. That was particularly around things like notices, but also I won't go through it, but it was a sensible move, and it basically moved all of the duplicated provisions in Chapter 2 about payments, benefit types, and Chapters 6, 7 and 8 all moved from the Social Security Act into the Social Security Administration Act. And separately they created the International Agreements Act, which took Part 4.1, portability, and the international agreements. So the Social Security law, from the commencement of this package, I think it was 20 March 2000, we had 3 acts comprising the Social Security law, and then 2 new acts, a New Tax System Family Assistance Act 1999 and a new tax system, brackets Family Assistance brackets Administration Act 1999, which created the basically the new benefit types of family tax assistance, childcare benefit, and some other child-related payments. And those were moved essentially out of the Social Security Act. You know, in the old, previously the payments were the family allowance and the family, you forget them all, there's just been so many iterations, additional family allowance, God knows. You had to, and one of the problems we have in Social Security, of course, is that everything changes. Like this, you know, the names of the pensions change, and then they close them, they shut them down. They have widows' allowances, then they have widows' payments, and they have neither. One of the real problems, and it's a very important in this field of debt recovery, is that while the Act changes all the time and people get closed out, you know, the benefits are cancelled and so on, or legislated, what happens is that we have the payments, as you get a payment under one of these repealed benefits, if an overpayment arises, then Centrelink has no hesitation in going back 20 years to try and recover debts, so that you may find that when they raise a Social Security debt, say against an elderly woman now on an age pension, but who perhaps hadn't declared an income, or perhaps hadn't declared a partner 30 years earlier, the overpayment will go back to the 1970s or the 1980s. It will run through a whole series of benefits, starting with the, what is it called in the old days, before the sole parent pension, and then it'll move to the age pension and so on. So you get a lot of different payments, and each of them have timelines, so that you've got to work out entitlements in relation to each fortnight or each week or each month, each year. And these overpayments, when they finally arrive, can be enormous, very large, go back over 20, up to 20, 30 years sometimes. And the records are usually very poor. And you know, it's very hard to get together the records to try and disprove, you're not. In fact, what Centrelink is ones should be trying to prove these payments, the payments. But in fact, you do need evidence from your side to show why the Centrelink material is incorrect, because what they've got generally is computer records that have been entered contemporaneously over, you know, that 20-year period, and not necessarily correct. I've always been offended by the fact that the debt recovery provisions sort of have no time limit. They will go back to the 70s or the 80s. But on the other hand, if there's an error made by the department which results in an underpayment to the client, then of course you basically can't go back. You're limited generally to about 3 months, unless there's been some problem like the department didn't advise you about, didn't give you the right notice, in which case you can backdate. There are circumstances which you can backdate underpayments, but the fundamental rule is you can only go back about 13 weeks. Very unfair. So Chapter 5 in the paper, I talk a little bit about how Chapter 5 developed. Chapter 5 is called Overpayments and Debt Recovery. It's probably, there was in 1993 there was an attempt to tighten the debt recovery provisions quite a lot. It failed in the end. It was badly drafted. There was a federal court case in Lee versus SDSS. All in all, it failed. And we had the 1995 Act and the 1996 Act, which put significant amendments through to the overpayment, debt and overpayment provisions, and it really established the structure that we have now. It's been relatively stable since the 1996 amendments. And one of the notable things about that 1996 structure is that if you've got an overpayment, in most cases you'll have a debt. We've got to the situation, unlike the 1947 Act, where an overpayment essentially equals a debt. There are exceptions to that. In particular, you can see some of those exceptions around the family tax benefit and the fact that it's annualised. But that's generally the rule. We had, in 2001, there was some Actually, sorry, it looks like the 2001 was the one where they finally just got to that point. And since then, it's been fairly light in terms of legislative amendment, particularly when, if you look at the pace at which the rest of the Act has been amended. But there was one Act, the Budget Savings Omnibus Act 2016, where the department did come back to this part of the Act, or this chapter in the Act, and what they did was they applied a new interest charge to outstanding debts. The previous interest regime didn't work; they just stopped using it. Those interest charges essentially apply where the person has failed to enter into or has not complied with an acceptable repayment arrangement. So there is a condition about the interest, but as we saw in the robo-debt disaster, these interest penalties were coming through to people who hadn't even been told that they had debt, let alone the opportunity to negotiate about repayments or whether the debt was in fact a real debt. So one doesn't have a lot of faith in these interest charge provisions and the qualification on it. The other change was the introduction of departure prohibition orders, which I'll talk about a little bit later. This is basically being able to stop a debt or a significant debtor from leaving the country without leaving behind their debt. It's based on a Child Support Act provision, and also they removed the 6-year limit on debt recovery. So it was a number of issues, not enormously important in money terms, in savings terms, but did sort of put a bit more sting in Chapter 5. Okay, now I'm going to move on to a contextual issue. Let's have a look. This is the importance of language. Now, this is probably the thing that I most want to go over from last time, that I think looking at this a second time is important, because there is a misuse of language or a misunderstanding of language about Social Security. And what happens is that politicians and journalists and clients and all of us use terms interchangeably or incorrectly. And so what you get is the tendency of our ministers to conflate what is in fact a debt or an overpayment with fraud. And so you get it becomes very important to identify what it is you're talking about and use that language correctly. So the first one is an overpayment. So an overpayment occurs where a customer receives an amount of payment higher than authorised by the legislation. This may occur through official error, customer error, timing issues, omission or deception. So overpayments can arise in all sorts of ways, but one of the ways is, of course, Centrelink error. In fact, that's a significant proportion of the total amount of overpayments. Failure to properly code when a notice is received by Centrelink, failure to properly code it in the Centrelink system. There's all sorts of ways that error lead to customers having an overpayment and therefore a debt. A debt. What's a debt? Well, a debt arises where the legislation provides that the customer owes a debt to the Commonwealth because of the receipt of an overpayment, so that's easy, or some other ways that a debt might arise: imposition of penalty interest, which I talked about, recovery of an advance, or other reason. So not all overpayments result in a debt, particularly under the former 1947 Act and the adjustment provisions of the Family Assistance Law. And also, when you have debts, not all debts are recoverable. There's situations in which debts, while they exist, they're not recoverable, and an example of that is bankruptcy, which I'll talk about later. Error. Overpayments may occur because of error by Centrelink, which I generally call administrative error, by a customer, or a combination of causes. So error, it works both ways. It's not, it's quite wrong to sort of say that every overpayment is a affront to the taxpayer, because a great many overpayments actually arrive from the department itself. Then we move to compliance activities. Now, this is a general term used by the department to describe its processes for prevention and identification of overpayments. So inside compliance activities are data matching is one of the best known examples, but also there's a certain amount of investigation as well, particularly in relation to Dobbins. But compliance is the compliance activities a high level of computer programming involved. Now, non-compliance, this refers to a failure to comply with a statutory obligation, usually, but not necessarily, with some connotation of knowing or reckless conduct. So when they start talking about non-compliance in say annual reports or in brochures and so on, there is an element of failure there. It's failure by the client. Serious non-compliance is used as a general description of fraud or associated behaviour. So once you start talking about serious non-compliance, it is sort of like almost a synonym for fraud. And then fraud is an activity which is an offence under the Social Security law, the Family Assistance Law, or criminal legislation, such as the Criminal Code and the Crimes Act. An offence may be committed under Part 6. Oops. I think it's gone off the screen. We've missed a bit on the screen there, but I won't worry about that. So I just wanted to reinforce this thing that you've got to really be careful. Overpayment, debt, and error, they're almost neutral terms. On the other hand, fraud involves a deliberate fraudulent conduct, and we just can't allow the laziness of people saying that there is billions of dollars of fraud, or $1 billion of fraud, simply because there is $1 billion of overpayment in the system. Much of the overpayment is caused by administrative error. Other parts of the overpayment are caused by customer error, genuine non-intentional customer error, and then a small proportion, surprisingly small proportion, comes down to deliberate fraud. Now, deliberate fraud in the Social Security system is the key areas of deliberate fraud are, of course, the creation of multiple identities or collusive activities with Centrelink officers, which unfortunately happens. So the people, essentially the receipt of many benefits and creation of identities, usually to receive those benefits. There's also fraud which comes to a deliberate failure to advise of an event, but a lot of what would be characterised as fraud is really just sometimes carelessness in actually identifying what should be reported. One of the most common is people reporting their after-tax, what they actually receive, their after-tax income, when it needs to be reported as their before-tax income. And that can be characterised as fraud, but it's certainly an overpayment results. A debt certainly results. There is certainly a customer error, but whether that is fraudulent behaviour, I think, has to come down to the circumstances. There can be a deliberate intent, like, for example, a person who has had a job for a long time and then applies to Centrelink for a benefit, knowing they are not talking about that job and knowing they're not entitled. They're certainly moving there forward. Then they are committing an offence, of course. But many of the levels below that, it's really coming back to errors, and sometimes errors that are based a little bit on willful blindness. But it's a gradation, which I'll talk about later in the presentation. But the point I really wanted to make is just take careful of language. Now, notice I'm really taking too long here, so I've got to speed up because I really do want to get to the core of part 4. I'm just looking at the result of that poll, by the way. Okay, we've got 20% considerable Social Security and 50% sub, so that's an interesting group. Rightio, moving on. Oh, it looks like my Carly, you might have to help it. I'm wondering why there we go. Okay, I'll run through this pretty quickly because I did cover it last time as well. Chapter 5 of the Social Security Act 1991 includes Part 5.2 about amounts recoverable, Part 5.3 methods of recovery, Part 5.4 non-recovery, and Part 5.5 departure prohibition orders. An important thing about Chapter 5 is that it's a code. Walker v. SDSS is the case, 1995 full federal court, an important case. Why this is relevant is that it means that the Commonwealth can't just go off and collect debts using executive power or use imaginative ways of raising overpayments. Chapter 5 of the Act is quite explicit about what is an overpayment, how it's raised, how it's recovered, and how it can be waived. And it creates entitlements in recipients. It's not a matter of discretion generally. So it's always worth remembering that it's a code. Looking at them, the amounts recoverable under the Act, I'll just go to, importantly, Section 122A. That's if an amount has been paid, it's a debt, if and only if it comes up under the Act. So that's creating the code essentially. And then Section 1223, and this is the one that creates a debt from the overpayment. That's all I'll have to say in that. And the other way the debts are raised under the Act are sections like debts arising from prepayment, debts arising from AAT stay orders, debts arising. But there's a whole, in 5.2 has an immense number of provisions providing for debts. Every time they create a new payment, they have to create a new section to create a debt. So the one-off payment to care is mirrored by every time they do a one-off payment of some sort, there'll be a section in Part 2 of the Act, 5.2 of the Act, that makes it a debt. It also brings in debts, can bring in debts under Section 1228, can bring in debts from other legislation, in particular the VEA, the Family Assistance Act, and the new MERCA Act, the Military Rehab Act. 5.3, methods of recovery. It actually sets out the methods of recovery, and really that, because it's a code, that's it. So Section 1231 is of course the one that's used most, the deductions from the debtor's pension benefit or allowance. Then legal proceedings, in other words going to court for the debt. Garnishee notice, which is used actually under the Social Security Act, just issuing a notice to someone to pay an amount. It might be an employer, it might be a bank, or it might be, for example, a tenant if you are a lessor, and the Centrelink has the capacity to actually issue a garnishee to that agency or person, and they pay Centrelink rather than you. And so that could be, it's a substantial power. But legal proceedings and garnishee notices generally arise, one, when the person is not receiving Social Security, because deductions are the usual method for recovery. And secondly, there are some restraints about garnishees and legal proceedings. They're fairly blunt instruments. And then, of course, there's the final one, that there can be an arrangement for payment of debts. And sometimes, in particular, couples will agree to repay a debt. You know, the debt is actually incurred by one member of the couple, but the other member of the couple also agrees to recovery. Now, I do a lot of, I've got to do a hell of a lot of work at Legal Aid and through the Electricity Ombudsman with people who are on in hardship, financial hardship, and I would say that of the people we see, the significant majority of those people on Centrelink have taken Centrelink advance and are having that advance recovered, and also they will also have a debt usually as well. And this goes on top of the deduction comes out of the pension. But my experience is that these days the amount of deduction is usually, it's guided by policy, and you can generally have it adjusted to meet the particular circumstances. Okay, we move on to bankruptcy. I'm actually just talking ad lib here, not looking at the paper, but I think with bankruptcy I'd better just quickly look at the paper. Okay, it tricked me. The heading was on one page and the discussion was on the next. Under the 47 Act, there was a suggestion that you couldn't bankrupt yourself out of your Social Security debts, but that's not the case under the 1991 Act. Essentially, if you go bankrupt, then your Social Security debts will be irrecoverable because of the bankruptcy, unless, and this is a really key condition, unless it was incurred by fraud. So you've always got to, when you're advising people who are considering bankruptcy, you need to be very clear, give very clear advice about the fact that they won't necessarily get rid of their Social Security debt through the bankruptcy if the department decides that the debt was incurred by fraud. Now there will be the capacity to seek review on that particular decision, but the first choice will actually be first you'll probably tend to hear of it is when the department raises it, because fraud's a big word, but and that's it, in the Bankruptcy Act. The actual language is a debt incurred by means of fraud. So it becomes really important as to what is fraud. Like, for example, if the allegation is there was a customer error, innocent customer error that led to an overpayment in a debt, then that's not fraud, and there shouldn't be a negation of bankruptcy. On the other hand, if there was a knowing and deliberate breach of the provision of the Act, then the argument will start to arise that it's fraud. And this sort of conversation about what's fraud and what isn't is very important in the waiver area, because there is some waiver is not possible if there was if there was essentially a fraudulent activity by the person. I do mention one case in bankruptcy, and that's the department in Grindley, 2005. The respondent was overpaid parenting payment of $12,800 because of her husband's income. The tribunal held that the debt was divisible, and the respondent was responsible for the overpayments which accrued after the date of her bankruptcy. The amount which accrued before the bankruptcy was only $600, was provable and was no longer recoverable. So you go bankrupt, your debts can still accrue, which when you're an advocate working with people who may go bankrupt, it's really important to work on their budgeting skills as well, because in the electricity area they bankrupt off their electricity debt of a couple of $1,000s, but if they don't actually change their usage of power and become more effective in the way they use the home, then they'll probably have a debt of $2,000 and be facing disconnection by the time they get out of the bankruptcy. So unless you actually change the energy efficiency behaviour in the household, or some other way, in some sort of intervention to try and reduce the utility bills, then the bankruptcy itself does nothing but just get rid of a particular debt at a point in time and doesn't solve a problem in the longer term. Okay, waiver and write-off. This is important. The paper will go through some of the legislative history. I suppose the main point I'd want to make is that there was a very broad discretion in the 47 Act under Section 251, and the Hales decision sort of set some principles for that. And there were a million cases, about overpayments and debts and write-off and waiver and so on. And they're still collected to some extent in the book that Alan Anforth and I write, which is referenced in the paper. The situation we're at now after the various amendments through till 1997 is that there is still a provision in the Act for write off a debt, but there's not a lot of utility in actually achieving a write-off. If a person is receiving a benefit from Centrelink, then there will be a deduction from that benefit, and it'll be an amount which is generally set by policy and can be changed. So you can get a write-off of that sort of obligation to have the deduction for a period of time, but I'm not sure it's particularly useful. Where write-off becomes important is, of course, where the person doesn't currently receive a Centrelink benefit. That's quite common in the family assistance area. What they've got is a debt that has arisen in the past, either from their sole parent pension or family assistance, and they're no longer a Centrelink client because their situation is usually because their situation is improved, or it may be because they got married and now their partner has too much income. and they're faced with a situation they have very little income, or very, very difficult situation. But the only way the client can, the department can get the money is to garnish and take legal proceedings. And so write-off can be quite useful in that context. I won't talk about it too much because, as I said, well, I don't think I said, but I think the important thing is that waiver is basically where the game is at now, rather than write-off. There's some interesting stuff in the paper, but I'll just move forward because of the timeline. I take too long on these things. I'm far too detailed. So we'll talk about waiver generally, and that's done under. So I'll move past write-off, and I'll move back. Okay, my slides are not particularly useful. I'll stay here. Okay, so waiver. Waiver arrives out of, let me see, sections 1, 2, 3, 7 is the primary section. Section 1, 2, 3, 7 actually gives the general power to waive, and then there's sections 1, 2, 3, 7A through to 1, 2, 3, 7AB, which have all sorts of different types of waiver in them. For example, just running through them, 1237A is the administrative error. 1237AA is waiver of debt relating to an offence. AAA, waiver of small debt. AAB, waiver in relation to settlement, that's settlement of legal actions. AAC is waiver where a person would have been entitled. Now I call that notional entitlement, quite important. AAD, waiver in special circumstances, that's the big one. And then extra rules for waiver of assurance of debt, assurance of support debts, and Secretary may waive debts of a particular class. So going through that, moving on from write-off, the waiver, I said section 1237 gives the power, and just speaking generally about it, the 1237AA, which is offence, what that does is it says that if a court indicates in its sentencing in sentencing the debtor that it imposed a longer custodial sentence on the debtor because he or she was unable to or unwilling to pay the debt, you can actually get a waiver of that amount. There's a series of cases which are in my book, the third edition of the Social Security law, worth looking at. The main thing in that particular one is to look very carefully at what the magistrate or the judge actually indicated, because it's got to be that they have they've actually imposed an additional custodial sentence because of the circumstance around the debt. So, and the indication needs to be in the certain sentencing comments of the magistrate or of the court. You can't sort of go to extraneous material to try and show it. Waiver where the person's or debtor's partner would have been entitled to an allowance. That's 1237 AAC. It introduces a very small sort of notional entitlement waiver, but it's really a very little practical significance. It only applies to a narrow band of benefits. The really important one is that you can argue notional entitlement as a ground for special circumstances waiver, and that's where the game is. There's some extra rules for waiver of assurance support debts, 1237AE. The basic thing there is that this section doesn't preclude waiver of assurance of support debts, but it does place a restriction on waiver, providing that the special circumstances waiver must be justified on grounds other than one or more of the assurees was unaware of the effect of the assurance. So in other words, it's just a specific one for assurance of support. And also they can't waive, prevents waiver of any amount that can be recovered by an enforced sale of the security. There's a couple of cases that I've put in the paper which is worth looking at. I also covered the issue of waiver where the debt's been repaid. Sometimes it's been suggested that if it's already been repaid, you can't go through the repeal process on. We've got a case, Varco and Department 1998. I think it establishes pretty clearly that the tribunal does have a function of actually looking at the debt even though it's being repaid. Not to do that would, in the tribunal's opinion, would have created massive inequality. Okay, now we'll get to administrative error. That's the key one. Fairly short section. The key elements in it is that it has to be, the debt has to be attributable solely to an administrative error made by the Commonwealth. So attributable solely to an error. Second, sorry, that was the first is the attributable solely to, so that's a very, very tough causal test. It must be an administrative error made by the Commonwealth, and the debtor must receive in good faith the payment. Quite, you know, there's a lot of cases on this, and I'd refer you to the discussion in the third edition of the Social Security Family Assistance Law Book. It's page 666 to 682, where we go through all of, you know, massive number of cases in this. I just give you a little bit of a warning that the way to use these cases is to try and find patterns. You know, that there's been a number of times in which the tribunal has, you know, felt this was an administrative error or whatever. They're not, tribunal decisions are not precedents about you know, what is an error and so on. So you're just using the other cases essentially to understand the boundaries that you're working in and trying to find a couple of cases which support the proposition you're putting. And when we get down to attributed solely to, it's clear that it is that solely means only or to the exclusion of all else. That's basically full. That's federal court, Gerhard versus education, employment. And what else can I say? The other thing is that the assessment for administrative error is essentially objective. And that's a case full federal court, Secon and the department, 2003. So AJ said, the ordinary or usual interpretation of the phrase attributable solely to is that it refers to the single sole or sole cause of the relevant act or event. The word attributable means capable of being attributed. It involves an objective assessment of causation. The words a debt attributable solely to an administrative error can be paraphrased as meaning that the only cause that objectively can be ascribed to the relevant debt is an administrative error. It's a fairly tight test. And then, you know, there's a number of sort of cases, just sort of, for example, where a debt arises from more than one cause, one of those is administrative error and the other wasn't. Section 1237A1 permits the waiver of the part of the debt that was attributable solely to the error. So you can actually get a little bit granular inside the error and say, well, this error was solely attributable. Sorry, this amount of payment was solely attributable to the debt, even though there's a wider context. It's important just to bear that in mind. The administrative error has to be by the Commonwealth. It's not a question of administrative error by Centrelink, it's the Commonwealth. So that can bring in, for example, in some cases, it's brought in Commonwealth Employment Service, Australia Post, an interesting one, Commonwealth Agency. That was Fax and Mackenzie, 2003. There's a little bit of, this case has gone a little bit both ways in relation to the job network, but I'd say there's Anderson and the Department 2006 that found that administrative error by an employee of a job network provider was an administrative error by the Commonwealth. I would strongly support that case. I think you have to really fight any suggestion that the job network provider is not the Commonwealth, you know, that it's some sort of private entity. Whether you argue it as agency or they're obviously not the Commonwealth itself, but the nature of the role they play can mean to say that the error does then impact on the client. It may be that the error is in fact made by Centrelink in any case, but in certain fact situations you may need to go back to an error of the job network provider, and I would be pushing very strongly to rope them in. But again, there are decisions that go the other way on that. The good faith requirement is a really difficult one, unfortunately. Prince, the case to look at is Teacher and Prince. If you thought there was something, you thought you were not entitled, but really not sure, it's not received in good faith. What's happened since Prince, and you need to look at that case carefully, is that the principles have been sort of worked around by subsequent cases, and there is a question of genuine belief in there. In Haggerty and Deitch 1999, French J held that the tribunal had failed to consider the actual state of mind and knowledge of the applicant, this being an essential element of the lack of good faith. So that's a useful statement. I would work through the cases that I've listed in the paper, and there's quite an interesting summation, which is just a recent one. SDS and Timmins in 2017. It involves a Q-Super problem, in fact, which has been seen in Queensland. And the tribunal emphasised the subjective nature of the good faith test. And in this case, elderly people were had a lot of things in their lives, very unfortunate things happening, and they did receive the amount in good faith. I won't go through administrative assurance debts. There are assurance of support debts. There's some curly ones there because basically the person who received the payment in good faith must be the person referred to in this section, so that in assurance of support, the person, it's two different people, so you've got some problems there. But with assurance of support, just have a good look at the cases in the book and think about them, and I've extracted a couple in the paper. Moving on to special circumstances, it's really just a general discretion, but the key reservation is that there must not be a knowing statement. The debtor did not result wholly or partly from the debtor or another person knowingly. That word knowingly is a really important one, because it is a barrier to the special circumstances waiver, a full barrier. And so that the other ones is the other than financial hardship alone more appropriate to waive. They're generally not particularly, they don't arise particularly commonly in the cases. I've brought a few into the paper, but I think knowingly is the really important one, because the question is basically what level is required for being knowing about this. It's clear. Well, there has to be some level of intent in the making of a false representation. There's a couple of cases there, but there's a shading between intent, false intent, and sort of moving down to sort of ambiguous situations where the person was aware of the false statements and made them knowingly, but they weren't aware of the context or that it was actually a contravention. Or there's a situation with sort of statements that are just made recklessly or, willfully blind. The explanatory memorandum didn't help us on this because it said knowingly covers deliberate fraud as opposed to innocent mistake. Now that's easy. Deliberate fraud is clear. Innocent mistake is also pretty clear. But a grey shading area in between. And I think you've just got to look at the cases. They're not completely consistent, but I think we're starting to see. There's certainly it is a test of actual knowledge. There is a reluctance in any way to allow for a constructive knowledge of a false statement or false representation or a failure. So you're looking for actual knowledge. But there's a case, for example, throwing a blind eye and throwing a Centrelink notices in a drawer is a knowing failure to comply. That's Woolley, 2009. So when you get to that situation where the person sort of, the willful blindness situation is the easy way to describe it, that can become knowing. And another case which is contrasted with that is that a history of mental health problems or other crisis-driven background issues may lead to a state of mind where the person does not have knowledge of his or her obligations. That's Wilson in 2011. So that's sort of two cases different sides of the fence of the line. The false statement may be the knowing act of the debtor or of another person. So, that unfortunately in the case of Ellis 2000, there was, somebody received the money and somebody else forged the documents while he's in prison. Could not waive because another person had knowingly defrauded. And that's also comes up quite a lot in relation to assurance of support, where you've got an innocent person who gave the assurance, but the person who was benefiting from the assurance, the surety, gets off and does a false advice to Centrelink. I've listed some cases where waiver's been approved and cases where waiver hasn't been approved. The main thing I'd say about them, read them, think about them, but it's important when you're going for a special circumstances waiver to actually try and put as many considerations on the table as possible. Certainly, just financial hardship is not going to get up. It's fairly specific under paragraph B. But there's a case, for example, in the thing where what the person was describing as their circumstance was essentially the circumstance that most people on disability support pension would suffer around their medical issues and their financial statement and the financial things. That wasn't going to get them up as special circumstances. On the other hand, there's federal court authority, which is in the paper as well, saying that special circumstances, not exceptional circumstances. It's so that it's a very hard one to describe. But what I'd say is that flesh out your special circumstances, and quite often the tribunal is more willing to find special circumstances when there is a number of different circumstances and they're interacting with each other. In other words, it's not just each special circumstance. Each circumstance leads to a special circumstance, but it's the fact, the interaction, the multiplication, the effect of them together, the way they interact with each other, actually makes it special. And that's probably the main thing I'd say about it. Have a look at the cases that I've extracted, and if you've got a case itself, if you're running one, then get there into, get into the book and have a look. I just want to talk about notional entitlement. First of all, administrative error. Administrative error can get up a special circumstance. There's no problem there. There's a federal court case, Fax and Secon, 2003, which quite explicitly says that administrative error can be special circumstances. So basically ignore all the cases earlier than that which were saying the opposite. And this is the way you get around perhaps your good faith issue. If you can't get an administrative error up because of the good faith issue, you can still bring it up as a special circumstance. And I've mentioned a few cases about administrative error. In fact, it's quite a common ground for getting the special circumstances up. And the final one I want to talk about is notional entitlement to another benefit. There's been a lot of difference of opinions about whether that was a goer, but that's been cleared up quite specifically by the federal court in Overhart and Dewar, 2008. Spender J held that a notional entitlement, quote, should not be excluded from the range of relevant considerations in deciding whether there are special circumstances to waive a debt under section 1237 AD. So that's explicit. And the notional entitlement quite often comes up in relation to New Start, where a person on youth allowance stops going to their course and because they're in a depressive state and they don't leave their bedroom and stuff. You try to argue they would have had New Start sick in any case, and then allow that notional entitlement to be offset. as a waiver. And the cases, the cases I've mentioned show that the notional entitlements can be approved as special circumstances. I even put a few recent ones in, one from 2015. But have a look at those. But the final sort of takeaway message that I would give is identify all of the relevant circumstances and then also work on their interaction with each other and present that clearly and concisely to the tribunal, and of course evidence. So I've proved to be a very bad timekeeper, but I think I've got to where we need to be here. I've said what I need to say about waiver and non-recovery, and in relation to departure group and prohibition orders, I just ask you to read the paper. They're not happening. They're not really happening yet, but we'll start to see them over time. And in terms of offences, the thing to know is just that offences may be prosecuted under the Social Security Administration Act, or if they're more serious, they'll be prosecuted under the Crimes Act or the Criminal Code. And of course, which act the DPP chooses to charge under is an indication of how serious they regard the behaviour. Under the Social Security Act, I think it's there's actually a limit on the penalty. What is it? Pretty sure it's 2 years. Let's have a look. No, 12 months. So if they proceed under the Social Security Administration Act, then the maximum penalty is 12 months. So that's. So when it's more serious, they will proceed under the Criminal Code. Okay, I'm sorry that, again, I proved a poor timekeeper, but I got through the key issues, and I would say please have a look at the paper. It will fill out on all the cases I didn't have time to actually read out. I'm happy to stay on for questions, though I think, it's Carly's in control of all that.
All right. Thank you so much, Peter. That's great. I will just mention that we did also get the results of the third poll that you sent through, Peter. So if you'd like to quickly have a look at that while I take some questions as they're coming through here.
Oh, this is this the bank? Which one was this? Which question was this?
So this is
the bankruptcy one.
Yes,
actually, that's not
bankruptcy.
Yes, so look. That's consistent. The 17%, yes, I've done it in the Social Security context, is consistent with the number of lawyers we have who've actually have a practice in Social Security, and the 58% is, well, I think pretty obvious because, when you work in legal aid or work in a community legal centre, you're always coming across the other contexts. So that, if anything, the 25% is a slightly surprising figure. Okay, great.
All right, and would you like that last poll sent out to the people we have left while they're thinking of their questions? No. Okay, fantastic. So I've got one here from Amber. Peter, you mentioned earlier that there is a much longer time period for recovery of Social Security debt. Do you know what the time limit is?
No, there's none. I think that's the simple answer. Like, with the robo debt, they were jumping back 7 years with Mary Abandon. There's theoretically there might be some. They've even removed the 6-year thing now. Essentially, they go back to whenever the cause of action arose. In other words, they say there was a particular act which gave rise to an overpayment and a debt, and they can go right back to that date, and they do. And that's why you're still seeing overpayments, generally against elderly women who are going back into the 70s and 1970s and 1980s in relation to most of their life.
Wow, that's full on, isn't it? And certainly some issues potentially for the clients that our CLCs are assisting. So I've got a couple of other questions, Peter. These ones were sent through by email prior to the presentation, so I'll read them out for Philippa, and hopefully you're online, Philippa. What is the best approach to assist a client with a Centrelink debt as a result of being paid while in custody?
Yes, well, actually, there's some stuff on paper about that. Well, if they're in custody, just look at the sentencing remarks in case there's a waiver there. But also, you need to look at their obligation to notify. Did they notify, but Centrelink not act on the notification in a correct way? that would give you an admin error possibly, or it may even mean the debt's not recoverable. There's an overpayment but not a debt because they didn't issue the right notices. But generally, just look at the circumstances. There was a case where you can certainly argue for special circumstances waiver in some of those. The thing you face, though, of course, is that the intention of the legislation is you can't, that you can't get the amount of money while you're in prison, and it becomes very hard when, of course, somebody else obtained the benefit while you're in prison and you didn't know. So situations like that, in particular, where the money came through, but it, ended up not being in the hands of the person, and for example, there might even be a notional entitlement argument somewhere sitting around. If in fact the partner of the person in prison would have had their own entitlement, perhaps didn't apply for it and continued to live on the entitlement of the person in prison wrongly. I know look at your circumstances.
All right. Just a reminder that you can write your questions in the question box on the GoToWebinar control panel if you want to ask Peter something before we finish up today. I've got one more question that has come through in the meantime. Again, this one's from Philippa. Are there grounds for a waiver even if a client has benefited from payments? For example, if their rent was continued to be paid while they were in custody?
Just read that first bit of the question again.
Are there grounds for a waiver even if the client has benefited from payments? For example, if their rent was continued to be paid back?
Okay.
Yeah.
Well, the whole point about waiver, well, there's likely to be an overpayment if they've received the money and they weren't entitled. So there's an entitled overpayment, and because it's an overpayment, there's likely to be a debt. But that brings you back to waiver. Just the fact that the debt exists, but are there circumstances in which that, even though they received the benefit, that it would be appropriate to write off the debt? They've received the money, but conceivably, for example, one circumstance, you've got to weave your special circumstances together, but, what happened? Did they get all the money and just go into their bank account and are now rich? That would be mitigating a bit against it. But if the money came in and it all went out on supporting the family, then yes, they didn't have an entitlement to the money, but and they received the benefit of it, or at least their family did. But there's certainly an argument for special circumstances there. And equally, there may be administrative error. Always look around for that. As long as there was not that knowing receipt of the money, and in jail, often you may not know you're receiving the money because you may not have access to ABMs and to the tellers, things like that.
Okay, so I think that's all the questions for today, Peter. So I might invite people to email through any questions if they think of anything later and would like those to be passed on to Peter.
Yep.
But in the meantime, thank you so much, Peter, for presenting for us again today. I hope everyone found that useful, and make sure you do have a look at the paper as well. That supplements a lot of what was covered today in the webinar. The recording of today's webinar will go up on our website on Monday, and I'll send that out to everyone who's registered for today's session. So thanks again, and have a great Friday afternoon, everybody.